Because let's face it, litigation is difficult, especially when you don't have the monies or the attorney or law firm backing you up. You're on your own, right? But not today, because I am here to help you. Hi, I'm Advocate Lucinda, and today we're going to talk about discovery and what you can do when the other party does not respond to or answer your discovery requests. You want to watch this video, so let's get started. So you made a request to opposing party for discovery, right? And the opposing party does not comply. Well, you can file a motion to compel discovery. What is a motion to compel discovery? Well, before we get into that conversation, let's go back and define discovery. What is discovery? Discovery is a process by which the parties request information and documents from the other side. The request is made through a written request for discovery. And again, I want to put emphasis on discovery. It is critical as a litigant that you be prepared to conduct discovery. You're going to use this information not only to make your case, but you can use the same information to refute claims of the opposing party. So that's critical. Be prepared to conduct discovery. Now, there are numerous tools a litigant can use to obtain information from the other side or discovery. The four you see here: admissions, interrogatories, production of documents, deposition, are the ones that we attorneys mostly use. There are others, but these are the ones that we mostly use. So let's look at these. Admissions is a request that another party admit or deny the truth of a statement under oath. Now, this is in writing. Interrogatories, they're also in writing. Questions sent to the other party that she or he must respond to in writing. And interrogatories are mostly open-ended questions, whereas admissions are closed-ended questions, right? Because the party admits or denies unless for some reason they have to explain, okay, their denial. Production of documents is a request for documents, electronic data, and physical items held by the other party. Now, the deposition is a little different in that where the other three are in writing, the person being deposed is deposed in person before a stenographer who take the dictation, and of course, the attorney or individual deposing the deponent. Now, there are some instances where depositions are taken via electronic for whatever reason, but you can look at the rules and it will explain when a party can take a deposition electronically. Okay? So let's get into the MCD, or the motion to compel discovery. What is it? It is found in Federal Rules Civil Procedure 37. It's a formal request to the court to require a party or non-party in a lawsuit to comply with discovery requests. And when is this motion filed? 1, when the party fails to respond or answer the other party's request for discovery, whether it's admissions, in interrogatories, production of documents, and depositions, because sometimes in depositions, the party doesn't answer a question. And if that party does not answer a question, the other party can file a motion to compel discovery. 3, when can this MCD be filed? When a person fails to answer a question during a deposition. We just said that. And when a non-party objects to request for production of documents under a subpoena. So what's happening here, even though you have a plaintiff and a defendant involved in litigation, but there may be an individual who gets pulled in some way, who would be a non-party to the litigation, but the individual propounding discovery upon that non-party has a right to do so, and the non-party must comply or otherwise show the court why he or she shouldn't be subject to the individual's request for discovery. Okay? When do you file the MCD or the motion to compel discovery? Under Rule 37, when a party fails to make disclosures or to cooperate in discovery, the other party can file a motion for an order compelling disclosure or discovery. Sanctions. The moving party or the party requesting the discovery can ask the court to sanction the other party for not responding and requiring him or her to file the motion in the first place. And what are we saying here? The court is not fond of parties not responding or cooperating during discovery. And I believe their attitude is, we will sanction you, party, for not responding, because what you're doing is requiring or pushing the moving party to file the motion in the first place. In other words, they would not have to file the motion if you just comply. So I would say to anyone hearing this, if discovery has been propounded on you, you need to respond. And this goes for both not only does the plaintiff file discovery request, but the defendant does the same thing. And in that case, the plaintiff needs to cooperate and respond to discovery. The court, again, frowns upon parties who do not cooperate with the federal rules. Keep that in mind. Now, this is important. Before you file your motion to compel discovery, you must make an effort to resolve the dispute with the other party. And you want to check the local rules. Now, in most jurisdictions, before the MCD is filed, the court requires that the party propounding the discovery file a certificate of good faith effort. This is after he or she has made efforts with the other party to resolve the dispute. And what this certificate of good faith effort says is that I have made an effort to resolve this with the other party, but they still will not comply. And then that gives the green light for the party to file the MCD. Now, you have done your due diligence. You made an effort to resolve the dispute with the other party. Now you can file your motion to compel. It must be in written format, and it must comply with the Federal Rules of Civil Procedure 37 and local rules. Next, you must serve the motion upon the opposing party. I hope this has been helpful to you. And as always, be